Greetings, this is Erick Widman from Passage Immigration Law, and we are happy to be with you again this week for our live Q&A about your pressing immigration questions. And we have a number of good questions that we'll be getting to you shortly. And the first one that we're going to be starting off with is it okay to get married outside the United States, then enter the United States on a visitor visa, and proceed with filing adjustment of status paperwork? So this question and a variety of basically slight variation on this type of question is asked all the time of immigration lawyers. And there are some key considerations to keep in mind. And so you're going to want to make sure that you follow the correct rules in regards to immigrant intent. So a restriction on what is allowed in terms of adjustment of status following entry as a visitor is a simple way to sum it up is you're not allowed to have the intent to immigrate when you enter as a visitor. When you're entering the US on a B1, B2 visitor visa, or maybe you're a visa exempt Canadian, if you come in as a visitor, you're required to have the intent to visit only and then leave. What is not allowed is to have this intent to come in on a visitor visa and present that status as the one you want and that you're coming just to visit when you really have the intent to stay here and adjust status. So this is a common challenge for many couples who understandably and justifiably want to be together for the long term, but it's the short term issue that's tough to navigate. So one way the US State Department has figured out how to determine if someone has immigrant intent or not is by using this 90-day rule. It used to be the 60-day rule, but under the Trump administration, it was extended to 90 days. And the 90-day rule, which USCIS also applies, says that if you come into the United States as a visitor, there is a presumption that there was the intent to immigrate, that there's a legal presumption is if you take action in 30 days of your entry into the United States that shows immigrant intent, you are going to have a difficult time getting your green card. The presumption is that you didn't correctly use your visitor visa, and you have to overcome that presumption. It's not impossible. It's not an absolute determination right from the beginning, but your USCIS immigration officer is going to be really skeptical and is able to require a huge amount of proof to show that you did actually not have immigrant intent at that point. So you have to come up with lots of evidence showing that, no, I was not going to get married and stay here and apply for adjustment of status until something changed, until these circumstances genuinely changed, until this event happened. So that presumption kicks in if you take those steps within 30 days of your entry. Right now, the 90-day rule presumption is if you take those steps 90 days or later of your entry into the US, there's the presumption is that you did not have immigrant intent. So you are able to successfully adjust status if you genuinely didn't have. That's the truth obviously matters. It's crucial that you did not have immigrant intent. And it's also required, it's essential that you are able to demonstrate that and use the presumptions to your benefit too. So for those who got married before coming to the US, that's okay. There's a human right to get married whenever you want, really. That's something the government should never be able to take away from us. But we have to follow their rules when it comes to immigration requirements. So the fact that you got married before coming to the US and had a ceremony outside the US, that could show proof that you're planning to be together with your spouse, because most spouses, of course, live together. And if you are moving to the US soon afterwards, it could be tough to overcome that presumption. So there's a long answer for you, but it's a common one. And I want to get this information out there again so that people can reference that and apply it to their own situation. All right, then, over to the other questions. How can I get a job that will sponsor my visa? So this is a good, general, very common question. And for example, when I immigrated to Hungary, I got the equivalent of a green card in Hungary. I lived there for about 2 years, and I got permanent residence, and I was able to work. I was able to get a job in Hungary. So coming this direction, coming into the US, how do I get a job that will sponsor my visa? So in the US, the vast majority of available jobs require a petitioner, sponsor, a petitioner who is also the employer. And so the most challenging part, quite often, is finding an employer who is willing to go through all the immigration hoops, jump through those, file all the immigration paperwork on your behalf, because it takes a lot of time and money to do that. In this tough job environment, though, it's a good time for immigrants in many ways, because so many people don't want to take on certain types of jobs, and many Americans are not willing to work certain hours or take a role that they don't like, or they're just not qualified. This gives you, as the potential immigrant, some leverage where employers, instead of paying a headhunter $15,000, $20,000 to find you, they might have to pay thousands of dollars to USCIS to get you your green card, but it's a good investment. It can be a worthwhile investment, but many employers are just scared off from attempting it. They have to be willing to take the time, make the effort to sponsor you, file the paperwork, and file Form I-140, do all the others, put together the required supporting documents, and meet the minimum requirements on your behalf. So it is a big endeavor, but what you have to do is get a job offer from that employer and get a commitment from them that they're going to be filing the paperwork for you. That's a simple way to sum it up. Next question. What are my chances of getting a green card with a profession of electrical engineering in Israel, and how long can it take? Okay, so congrats on being an electrical engineer. That's really tough. My college roommate was an electrical engineer. He studied nonstop. One of the key questions, though, that you might want to email us, support@passage.law, because you might have a doctorate, you might have a bachelor's, and that affects your eligibility in many ways, and also how much experience you have, what type of employment-based green card you're able to get. And I was pretty good friends with someone who had a doctorate in electrical engineering, and that person was also a professor, researcher, and he worked for industry. So we would need more details to find out, for example, could you do an EB1 visa that would allow you to avoid having to have an employer? You could self-petition. You might do an extraordinary ability visa, an O visa. There's a lot of different options. National interest waiver. Through your profession, you could figure out all kinds of things that could help the US. And so, yeah, get in touch, support@passage.law, and our attorney, David, will get in touch with you and answer your questions further once we get more information. Okay, how can I, as a 50-year-old Dutch woman, work and live in the USA without a high education or extraordinary profession? Well, I love the Netherlands. My wife and I visited there a few times. And so, yes, wonderful country. Glad you're considering the US as well. So the three main categories for immigrating to the US are family, business, or humanitarian. So you're from the Netherlands and there's not a good reason to apply for asylum from there. That wouldn't fly. So humanitarian basis is for Western European citizens is pretty tough. So business category, that is possible, like I was describing earlier, if you find an employer who's willing to sponsor you for either a non-immigrant visa or an immigrant visa and get you a green card. So you maybe didn't finish university, uh, and like you, most of us are not extraordinary. Some of us are extraordinary. You can still get a job offer in a compelling position. So, for example, a couple of our clients are restaurants and they are hurting for people to work in the restaurant. And lots of people are unwilling to take those jobs, and it's on the coast. So it's difficult to find people willing to take on that position. So you might want to contact different potential employers where they're having a hard time finding locals, US citizens who are willing to do the job, and see what comes of that, depending whatever your skill set is and your experience. And a couple other things, and of course the final category is family. If you had a fiance or a spouse or a close family member, an immediate relative who could petition for you, that would be a child, spouse, or parent. That person would need to be a US citizen. In some cases a permanent residence is okay. But if you don't have a family member like that, you would have to look at some of the other categories. There are some short-term options to come to the US, for example, on a J1 exchange visitor visa. And you could always be a student. Expensive, but worthwhile. Lifelong learning. I plan on it. All right. So we're going to keep moving on here. Next question. My 18-year-old nephew, through adoption, lives in Ethiopia and would like to come to the US. What type of visa has the best chance of being approved? So your nephew, you as the uncle, you don't have a close enough family connection that you could petition for him. The other main category, if there is a family member who's in the US, I'm doubting this is the case, but if your nephew had a parent or a sibling, a spouse, a closer family relationship than nephew, uncle, that could open some doors on a family-based petition. But nephews are often college age or younger, and so a student visa, F1, F as in Frank, student visa, J1, exchange visitor visa, those could be good options as well, especially for a younger person. And a common pathway, come as a student, get a degree, do some optional practical training, OPT, or curricular practical training, CPT, and you can get paid. Your nephew can get paid, get great work experience, and be sponsored. The employer would petition for an H-1B visa for your nephew, and then he could hopefully work on that basis for a couple of years, end up meeting someone here, so they could get married. That'd be a family-based pathway. Very common, of course, for people in their 20s to get married. And if that didn't happen, though, there are ways to pursue a green card through employment, and the employer could petition for your nephew. There's also a diversity visa option. That's random luck. And so that's worthwhile applying for anyone who's listening who wants, like the woman from the Netherlands, you could apply for the diversity visa. And that's still out there. It's still available to those 50,000 lucky people every year. The odds are not amazing, but it's worth applying. Thanks for tuning in. Let us know if you have any questions. You can always get back in touch with us. And I saw some other questions come in. We'll answer those next week or via email, support@passage.law. Take care. Bye-bye.